the situation on the ground, if I may approach.
You may.
I have an updated spreadsheet for you. Not much real change in the last week. We are working on getting a new shipment of water bottles, the 5-gallon jugs out there. Porta potties remain being serviced. I believe the court has been previously updated that an accessible unit was additionally placed out there. So we do have all the original porta potties plus an additional handicapped accessible unit. Apart from that, I don't think there are any real major developments on the situation on the ground. Obviously, we continue working with our community partners, working with the individuals there and trying to get people the resources they need to figure out how to improve their situation.
All right, it does look like you have about 49.
So, yeah, a head count I was given was 45. Some of the people on there have left the camp. I think that's noted in the notes for those that have. But yeah, I believe the most recent head count I was given was 45.
Okay. Yeah, I didn't go through all of them, but some of them it does look like they left on their own, but you have filled in at least, I think, 49 actions or people, so things are getting done. How many people are left? Do we know? I mean, there was about 60 to 70.
Mhm.
The number changed, sort of 50, then 60, 70, I don't know. And I did give you permission to the areas that would have been cleaned to go ahead and clean them. Is that being done as well?
There really have been no areas that have had a wholesale vacation, I guess would be the best way to describe it. So there really isn't an area where that would be applicable. Really, anything that has changed, you know, there's been, I think, and we can talk about this in a minute. Mr. Paul Brown, the owner of Pisano's, is here today, and he would like to address the court if the court wishes to hear from him. But it's such a transient, I think is the best way to put it, situation where one person leaves, maybe another fills in, or you know, one person takes down their tent, so another person kind of stretches out their space. There is some word I've heard of people bringing in and starting to kind of maybe erect newer structure type buildings. So again, the issue with the property being unsecure is that there's really nothing stopping people from coming and going as they will.
So do you have a proposed solution for that?
Apart from vacating the camp, clearing out the encampment and securing the property, I don't know there truly is one, Your Honor.
And as much as I'd like to see that happen, we're gonna be here with another case because they're gonna go on another county property or person's property, so.
They may, I would state to the court that I think part of the problem is the entrenched nature and the dangers, the specific dangers that poses, as opposed to people living in a more transient manner. You know, as you've seen from being there, we don't just have tents, but like the erection of actual structures. And I think people are more comfortable thinking they're fine to bring fire and such things into those kind of structures as opposed to a tent. And again, I don't disagree with the court, but I don't know that absent a you know, universal solution to the problem of homelessness, there isn't a need to just kind of break this up and hope that it doesn't recreate in exact form. You know, maybe it scatters, maybe some people take that impetus to get the help they need. You know, I think part of having a firm date is that it provides a sense of finality. Having moved recently myself, moving is not a fun experience, and it's one people tend to try to avoid. I can say the city is looking at solutions with winter coming in ways that maybe it could provide shelter, but again, those are in their primordial stages, and I wouldn't want to make a statement about them in open court.
So I know it's spread out. Is there a possibility of cleaning up even to begin around the edges so people realize that this is serious? I feel like I don't want to have caused a bigger problem where we remove 60 and 60 more come because they know they can get help that way. They need to start availing themselves of the resources we have. And I know it's a problem. I can't fix all of America's problem, but we have to fix this problem. And a message has to be sent that yes, we're being patient. And I want people to be treated humanely, but this is not a permanent solution. It is not their property and new people are not welcome. So I'm looking for some kind of solution there. I also am concerned about what I heard, and I don't know what we'll hear in December during the hearing, but it needs to be conveyed to city employees, to law enforcement, whomever, where they're removing people from one property, that property is also not allowed as a new home to displace people from other properties now to place them here, because I'm concerned about that issue. So that needs to be conveyed. I don't know how the mayor's office is conveying that or how the chief of police is conveying that, but that has to be conveyed. I don't know if we need to put up signs or what. But signs are just signs. They don't really do a whole lot.
I would agree, Your Honor. I can say that that message has been conveyed since the last time I was here. Again, part of the issue and part of what the city has sought from the very beginning and the solution we came to, with the property owner no longer part of this suit is that, as Your Honor said, it's one thing to remove the people. That is not a particularly difficult thing for us to do with a show of force, with police, to say you're trespassed. The problem is if we don't have the cooperation of the owner to clean up and then secure his property, it's a 6 to 12 hour solution. And that's where we've been at since the very beginning. So I think that really is the difficulty here, is that it's a permeable, at least from one side, situation. And if the court's willing to hear from Mr. Brown, I'm sure.
I certainly will hear from him.
The avenues come through, unfortunately, his property, through adjoining owners' properties, and they all feel the effects of this thing as well. And so that's certainly where we're at. I think there's also, it's difficult to say, well, we're gonna start picking this area up because then someone comes and says, no, that's my area. I haven't been, vacated. I haven't, it gets into a very tricky situation and a dangerous situation to some extent for our contractors and our officers. If there's people there on the ground, to be resistive of those efforts. So I think it really is very difficult without there being a true global solution to this site to really do and start doing any of that type of work.
Well, part of the problem is those pods and the buildings that are proposed by city council. Initially, when I heard it, I was really excited because I thought it meant this year. As I followed it in the news, it's like next year. So we've got these human beings. And honestly, I feel for everybody involved, but why are we going to shovel off people, treat them poorly, only to have them go on another property? You're gonna be right back here. I just want a solution. So, but I do think it's important that we do something to the parts where people have moved. I mean, there's only gotta be 20 people there. It's not 60 or 70 like it was.
The belief right now is that it's close to 40, Your Honor.
Okay, so that tells me new people have arrived.
Mm-hmm.
So how do you propose to police this, if at all?
I don't know there's a good solution. Again, part of the property is fenced now along the one property line based on the action of the other property owner. So hopefully that stems some of the flow. But again, without securing this property, it's going to be tough because I think we've heard, in the media, there's a certain set of residents that are very dug in and are very, this is my property and I'm not going anywhere. We have information, right, that people are now erecting new structures. It's tough, and the city certainly, doesn't have the resources, even as the city, to, sit several officers out there or have some sort of security presence, and not that that would be any sort of solution, and then we get into the notions of who can show they've been here and who's a newcomer. It would just be, it seems a very difficult issue to deal with, Your Honor. I would think with the winter coming, it tamps down on some of that transient, as we all know, right? There's less of the coming and going in the winter months. It's a less appealing option, but it truly is very difficult.
Well, new structures are not allowed. I don't know, I can sign an order, I don't know what we end up with there, and I certainly don't want to end up in some kind of shootout.
Mhm.
I mean, I can see this going from kind of peaceful and slow to deadly. I don't want that. So, but we also can't have new structures because that defies the logic here.
Mhm. That's certainly a concern of the cities as well, Your Honor.
I think
Mr. Booth?
I think Mr. Brown has an interesting perspective on what's going on.
Okay.
I think you find it interesting.
Sir, if you could come up to the podium. Thank you for being here,
Yeah,
please.
thank you, Your Honor.
Raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
May you put your hand down, please, state, spell your name for the record.
Paul Brown, PaulBrown.
I appreciate your time. I know your restaurant's always busy. I've eaten there many times myself. I know where you're located. I also saw it during the visit of how the encampment is encroaching.
Yeah.
What would you like me to know?
Well, the camp is growing just in the last 5-6 days quite a bit. I'm not sure where the numbers of 30 or 40 are coming from, but it's quite a bit more than that. There's been yesterday, I was standing on the back watching 4 or 5 gentlemen building walls, and then they were moving them from the east side of the woods to the far west side of the woods to actually build a structure there, not just a base for a tent. Since the woods were cleared out a couple of weeks ago and the fence was put up, it's pushed the people that were there over to the west. Nobody has seen to the left. Just way more traffic now. They've got generators running back there. They've got a large light that they put up at night. There's music playing all night long. And that part is not the frustrating part for me, but the amount of growth that it's like it's become an inviting place for other areas in the city where the people have come there. When I originally was dealing with this, I'll admit it was a nuisance. And then walking into my bathroom and seeing a guy with his clothes on my stall, taking a bath inside of my toilet there, then I had to step back and really say, buddy, what are you doing? This isn't okay for a human being to feel that they have to take a bath in my toilet, and.
Is this inside your restaurant?
Yes.
Okay.
So then there's the human factor of this, which this is not safe for anybody back there. The amount of drug traffic that's coming through there is went from a couple of times a week that it was noticeable to now it's just all day long. There's other things that are going back there. I'm assuming there's prostitution that's going on, but it's become a happening place at night, 7 days a week versus just maybe a Friday.
So tell me about that, because, so when I was there, and I don't know if they knew I was coming or not, I didn't see a whole lot of drugs, weapons, and all of that. I assume it's going on, but I mean, I was turning over things to see if I saw blunts and needles and what have you.
Right.
But if that's increased, has law enforcement been out? Are you calling law enforcement? Because obviously illegal is illegal regardless of where it is in this community. So I would like to see if there's prostitution, arrested. I mean, honestly, I haven't seen a prostitution charge by law enforcement or by the prosecutor in probably a decade. But it is illegal. In terms of drugs, we see that all the time. There should be an arrest. So, what's the deal with law enforcement? Do you call them? Are they not showing up? What's going on?
When I've had emergencies happen, and they're fast, you know, I'll have, the cavalry will be there in like 5 minutes. The police and fire, the fire department, the ambulance is there. I actually had, one of my employees, had a seizure on Sunday, and they were there in like 4 minutes. So extremely fast when it comes to that. And, for any times that we've had issues with guns, they're flying the drone. There's a half a dozen or a dozen officers there, like they're right next door, you know. So I haven't had that issue at all. With timing, they're extremely responsive. And I think from the mayor's office to the chief of police, they all see what's going on and want to come to a resolution to this. What do we do?
Well, if there's criminality, what we do is we house them in the Mason jail. I deal with that on a daily basis, multiple times an hour. So there has to be an arrest. So if that's going on, law enforcement needs to go out there and do their due diligence. That might clean out half the camp, might clean out all of it. That, you know, criminality, this order is to find housing, not to allow criminality. So if that's going on, we need to deal with the sheriff and chief of police for Lansing and get it cleaned up. Maybe that's the rest of our problem. I really don't know. I'm happy to go out there and tell people, you know, what's your move out date? I don't know if they'll listen to me. I don't know who's here from the encampment, and if there's is anybody here from the encampment?
I haven't really seen anyone today here for services or as representative, Your Honor.
All right, so if the need for services has dwindled and no one is showing up, then we need to have law enforcement go there, do a search. Based on what I've heard, I don't know why there can't be a search for drugs, guns, prostitution, and an arrest made if in fact that's happening. Because once those people are gone, the city is free to, or the owner, J is free to plow up whatever's there.
Okay.
I just, sir, you're in business and you've dealt with a lot of people over the many years. And you've been part of our community. And I know that you, the mayor, myself, I don't think I've talked to anybody who wants to treat these people inhumanely. They're down on their luck. We have to get them a safe place. But that does not mean they are allowed criminal behavior and a place to live that is unlawful. They can't just take property. My whole issue is this didn't happen 30 days ago or 3 months ago, but started 3 years ago, and the court finds out about it 3 years later. So now we've let it fester. So I don't think it is fair to these people to just say, you're out of here today when we've been there 3 years and it appears it's been permissive. So there's just a fine line I'm trying to walk, because they're clearly a holdover. They've made their tenancy there. They're a holdover. There's a right to the property owner and everybody around them to get them off because of safety. But we have the human issue. What do I do there?
Yeah.
I'm looking for solutions. So part of what you can do, and all the businesses there, have a chat. If you see anything, drugs, guns, prostitution, call 911. Let me know. Let the mayor know if they're non-responsive to those issues. Okay, I understand the seizure, they're coming, the fire department's coming, everybody's coming to help that ill person. But sometimes, and I hear from some neighborhoods that law enforcement's not responsive. They take gun matters into their own hands because it's an unsafe neighborhood, and they tell me law enforcement's non-responsive, so they have to carry weapons. Well, I don't believe that. That's not the law enforcement that I know that's dedicated to safety. But it's gonna take a community to call in those violations so we can get those people a home, in jail, possibly rehabilitative services in long-term facility for addiction or whatever, so we can meet their needs. I can't do that if there's no crime, if they're just squatting because they were given permission for 3 years to stay there.
Yeah.
I just think we all have to partner together to resolve this in the best way possible.
Your Honor, I would ask if you would come back out there because things have changed from the time that you were there about a month ago. I went out an hour after you were there, and it's much different now. There's several more people there.
Okay, we can't have new people, and I don't know what we're gonna do to monitor it, and I'm open to suggestion, and maybe we just take half of it and plow it. I don't know.
I have cameras on the back of the building, and I would be happy to offer you guys access to those to see the activity that's going on back there. I'd even put more cameras up back there.
All right, well, you know, I think that those cameras are evidence and should be turned over to law enforcement. Because if a crime is seen, that it's dealt with. And I think if the message is sent that we will arrest, we are there, you cannot be here, then people will move along.
Okay,
Counsel?
Thank you, Your Honor. Thank you, Mr. Brown.
all right, thank you.
Thank you.
I may approach just briefly. And first thing is that, you know, the last hearing that we had, you did issue an order. And we have tried to reduce that order to writing. We have sent it to the other side for their review. We provided them with a Word copy of it so they can make changes on their own. We don't have any response from them.
Do it in the 7 day, I'll sign it.
Well, I mean,
When did you submit it to them?
the end of last week.
Yeah. That's
Okay,
So, I mean, we can do that. I mean, and the other thing, I think having a firm outdate in an order from this court would be a significant tool in moving this forward for your consideration.
do you have a copy of the proposed order?
I do,
May I see it?
certainly.
Looks compliant to me. Here's what I've done.
Thank you, Your Honor.
I'm going to sign it. And I've added, if either party feels aggrieved by this order, a hearing shall be scheduled and a motion filed with specific objections within 14 days of this order.
Thank you. We thought that was an accurate representation, but we did order the transcripts to make sure, so I appreciate it.
Okay, so I am signing this. We're gonna get 2 copies. We're gonna get it entered today, so it'll be 14 days from today. and in accordance with the rules, have to plead with specificity about the hearing.
That in accordance with the rules, what?
They have to plead with specificity, so there's actual notice of what their issues are with this. It looks compliant to me. And then we're going to have, and I'm sorry, Brian, what I didn't fill out, there's a blank there about what time we start on the 15th. Can you just look on the schedule and tell me what time we just have Nicole put the time in?
Yeah.
I don't remember what time it starts on the 15th. Is that the day it starts?
Oh, yeah,
I believe it was 9 a.m. Your Honor.
Is it 9? Okay,
Yeah.
let me put that in. I didn't know if it was 9 or 1, but I'll put 9 a.m. then. And I am happy to come out and look, what are you council proposing that we do with, there's not supposed to be any new people. And if there's drugs, prostitution or other criminality, we gotta have arrests. I mean, that's the same in every part of the city
Your Honor,
or county or
yeah,
state.
I don't want to bring your honor out as part of a sting operation. So what I would suggest is let me speak with my administration and the chief of police and figure out how best to take a look at this information, which I was just provided today in the courtroom. And then we could arrange for an on-site visit for your honor at a time that you think is appropriate, given that information.
Okay, and then you'll let me know or let us know, and we can have a status conference or what have you, but, new people and criminality not acceptable.
Right, and we will communicate this to all parties.
Great.
Thank you, Your Honor.
Anything else for the record?
Nothing further, Your Honor.
All right, I'll see you next Wednesday,
Thank you.
or sooner if there's an issue you need to talk to me about.
Certainly, thank you.
Thank you, that's all.
We're gonna handle the two remaining criminal matters real quick, gentlemen.
This is docket 253725FH, People of the State of Michigan versus Anthony White. Counsel, your appearance for the record.
Aaron Robinson, Assistant Public Defender from Mr. White.
And where's your client?
I do not know. I've called his name numerous times.
And when was this?
I'm here.
Oh, you are? Mr. White is here on Zoom.
Yes,
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
yes, I do.
All right, thank you. And what are we doing here?
We would just be asking for a continuance in this case, Judge. Give Mr. White additional time to pay. Recently, I was just appointed probably 2-3 weeks ago.
Has he been paying on behalf of the people?
Not that I can see, Your Honor.
Sir, you haven't been making payments?
I haven't made a payment yet. I do have a bank account set up and I have been working with my athletes. I've been training them and I have been getting paid. So I was wondering if I can set up a payment so you guys can just take it out if that's okay.
Yeah, you're supposed to do that. That's not just okay, that is required. So you're gonna have 24 hours to start making payments, make weekly payments. I don't care how it happens. I don't care if you return pop bottles, sir. You've
Okay.
got a lot of money that you're owed. And if you don't do that, I'll just, hold you in the Ingham County Jail and we'll get this matter resolved the hard way.
Yes, ma'am. I will make sure I make a payment. Yes, I will.
And then this will be set for a continued pretrial? What have we done in this? I just let him out on bond to start working and he hasn't.
Correct, Judge. I don't know how the case was going previous before I was appointed, because I think there was a retained attorney on the case. But this is the sort of first continued pretrial. So we would ask for an additional pretrial, maybe 60 days out, if that's okay with the court.
On behalf of the people?
No objection, Your Honor.
So we're gonna have a pretrial January 14th at 9 AM. You
Okay.
need to be here or be here on Zoom. Let us know where you are. And the pretrial is going to involve you, the Attorney General, and your lawyer. And you all get together and figure out what's going on in this case. I expect to see regular payments, because I suspect the people aren't gonna work with you and offer anything unless there are payments. This is a time where you're gonna show good faith, and so far we haven't seen any. So get with the program or get locked up. Got it?
Yes, ma'am.
Thank you. That's all for the record.
Thank you. Your name? Clarissa, Clarissa Williams.
Thank you.
Mr. Starks, are you ready?
Yes, you are, yes.
Thanks for the promotion.
I need a second.
That's fine. I gotta sign this in.
Record for me.
Yeah, I need,
Have you seen that?
yeah, give me 1 second. Yeah, Oh, wow.
Oh, rude.
Maybe you can turn the volume down.
I am glad it's working again, though.
Yeah, we're also now on YouTube
Yeah.
to make sure we got double coverage for that. I don't know what that blip
So is it
was.
streamed or does it stay on YouTube?
I do not know.
I think it says live, so if it's live, I think once we're done, it's that.
I think we normally stay
Where it says live on the.
We only just started it. I don't know that I know enough about it, but we'll
Because
figure it out.
I know 54A, they stream to YouTube as well, and some judges, it's set to automatically like go away once the live stream is done. Some it stays for, months or years.
Oh, I don't know. We'll figure it out. Okay, who's next? I don't know where my schedule is.
Try switching them files.
Or here. I don't know.
What's next, Brian?
Sorry. James Richard versus Del Cooker.
Who?
James Sanders versus Del Cooker.
No, that's not what you gave me.
Is it not?
You gave me Walden versus Dexter.
Then
You gotta do this.
I gave you the wrong one. That's my fault. This isn't right here. It's my fault. That one should be great. I was gonna.
All right, this is docket 25, 35, 37, and 8. James Richard Sanders versus Delta Foot here in the seat is Dr. Brian. Counsel, your appearance for the record.
Hannah Roberts for defendants, Your Honor.
James Sanders.
All right. You should actually switch, but you finally are. That's okay.
No worries.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth on the penalty of perjury?
I do.
Thank you. You may put your hand down. This is defendant's motion for summary disposition. Sir, you're representing yourself, is that correct?
Hopefully not for the long term.
Well, if ever there was a time to get a lawyer, it's before this was filed.
So I'm hoping that you'll dismiss without prejudice
Well, okay.
because of the fact that I've had a couple of years of health issues.
Okay, well, let me hear their motion and then I'll hear from you, all right, since they filed it. All right, counsel, you may proceed.
Thank you, Your Honor. As you know, we filed this motion to dismiss in lieu of our answer due to the fact that plaintiff did not comply with the necessary requirements prior to initiating the lawsuit. First, a notice of intent was not served on defendants in advance of filing the complaint. When the complaint was filed, an affidavit of merit was not filed. Both of those are in violation of MCR 600-2912B for the notice of intent, D for the affidavit of merit. For those reasons, we're asking the court to dismiss this case today. We're asking for it to be dismissed with prejudice as the statute of limitations has now expired.
Is the
Statute of limitations has now expired.
now expired?
Now, yes.
Okay, thank you.
Thank
Sir, what would you like me to know in response?
So I brought the paperwork, the Spectrum to his office and they signed it and gave it back to me and I brought it and I filed it. I'm not sure because I'm not privy to the law.
Okay, which is why you need a lawyer, sir. Here's, the problem is when you file these kinds of suits, there are certain documents that must accompany the lawsuit. And you didn't file a notice of intent and there was no affidavit of merit. And that needs to be filed with a complaint signed by an expert who believes that your claims meet the statutory qualifications. So, sir, when would you, I know you've been ill, you just told me that, right? Okay. And have you had an opportunity to talk with an attorney?
Prior to the end date of 2 years, I did actually talk to an attorney. Don't remember who now, but they said that they wouldn't take the case because it was not enough time left to do anything at that point. That's why I'm here asking for an extension of the possibility of 6 months, I guess. And then I can get someone to take and work on the case.
So without, I don't want to violate HIPAA, okay, and this is not the date for the trial. In the last 6 months, how were you prevented from getting counsel, providing a defense, filing or I should say perfecting a complaint? How were you prevented from doing that?
So all I talked to was a lady that worked at a law firm. But anybody that I did talk to would not take the case at this point. They wouldn't take me on for counsel. And I can't afford to do it without it being a pro bono thing, or not pro bono, but where they would glean from it afterwards. And I'm not a suing type person to begin with, and my health is doing better. As you can tell though, there's still things, I was not in a chair previous to this, and half of my right foot being gone in pain all the time. I do walk some, but I don't walk a lot. And especially going any distance, I use my chair. And I really don't know what to say. I mean, other than
Okay, but you're claiming some kind of malpractice, correct?
correct.
And so, under the defendant's statement of facts, they're saying that Dr. Goosen noted that your wound had fibrous and necrotic base, and the right foot had considerable erythema and edema, meaning there's a lot of swelling, right? And so, I'm not a doctor, so bear with me here. But there were also significant arthritic changes to the midfoot area, and the doctor cultured the wound on the right foot and debrided both ulcerations. There was antibiotic gauze for the wounds. He sent you home with Bactrim that was supposed to be taken twice a day. You were told to go to the emergency room if you noticed increased swelling. You ended up going to the emergency room in McLaren, and that you were complaining of diabetic foot ulcers, chest pain, and feeling like you were going to pass out. And you had been taking the Bactrim,
Correct.
but complained of worsening pain and swelling. So, and you had already taken Keflex and amoxicillin. Amoxicillin, I think that drug's kind of overrated, it's overused, but that's my own personal opinion, which doesn't mean anything here because I'm not a doctor. But Keflex is a pretty strong drug. And then there was an x-ray taken, and they did a whole lot of work here. So
Can I respond?
just a minute, you're claiming that the doctor incorrectly prescribed Bactrim, which resulted in your foot being removed. So do you have any evidence, any expert you've met with that would verify that Bactrim should not have been used and that there was a mistake made here?
So 2 things. Prior to me going in, it was 7 days before they called me while I was in the hospital bed and said that they wanted me to get into their office immediately, Dr. Goosen's office. And I said, it's a little bit too late for that. because my foot had already been partially removed. Which the first emergency room doctor said that he wanted to remove the entire foot. This for a second opinion. They got back the information from within an hour that stated that Bactrim was not the right antibiotic to be placing me on to begin with.
Okay.
And they immediately started all kinds of IV drips and other things that were starting to turn all of the bacteria problem around. It didn't save my foot, but
Okay. So it appears that the malpractice occurred on June 28th, 2023. Do you agree with that date?
so. No,
So what date are
I
you?
think it was closer to the day that I went to the emergency room, which would have been the
July 3rd?
fourth. Yeah, and then it was in the emergency room late that night, I think.
Well, so it says on July 3rd, 2023, you were at McLaren Emergency Department, but it also says July 2nd, 2025, that's one day before the statute runs, you filed your complaint. So,
I get it. As I said, I am not a suing type person. And I realized that I probably pushed it further than I needed to. But that's why I'm here asking that the case would allow me to go before another attorney and see about getting an attorney to be able to present this case.
all right, sir, here's what we're gonna do. There is in the law, built in the law, where it's not possible for you to file within the time frames. We can extend and all of that. I mean, it sounds like you had some pretty serious medical issues, probably rehabilitation, physical therapy, whatever. So I get it, but the statute clearly ran months ago. So what I'm going to do is a bit of a compromise. I'm going to dismiss this based on the statute of limitation without prejudice. But prejudice will attach within 6 months from today, or actually from the day that defense gives me an order. And then your new attorney, hopefully you find one, can argue as to why the statute should be told because of your illness. Because it takes evidence. And the plain evidence here on the face says that that I should by every rights grant this with prejudice. But I do see and I read how ill you were. So I'm going to dismiss this based on statute of limitation without prejudice. The prejudice, however, will enter 6 months from the date of signing the order. And during this time, you can file your complaint, you can perfect it. But also, defense has the right to come here and make your client, your attorney and you prove that the statute should be told. And if I determine that it should not be told, then we go into dismissal with prejudice. Does that make sense to everybody? It's a little odd, I know.
A little bit. So the motions, I have a proposed order with me. I wondered if, and I was kind of trying to follow along.
I know, so
And
it's,
include.
it's granted as to statute of limitations, however, without prejudice
Okay,
for 6 months. If nothing happens within 6 months, it's with prejudice. I'm giving him 6 months to find an attorney, perfect his complaint, and explain to the court with case law, medical documentation, etc., as he should be doing today, but he's not a lawyer and he's been ill, that the tolling is proper by the court. You will have a claim that it's improper. He and his attorney will have a claim that it is proper and the case should proceed.
So if we don't hear from Mr. Sanders in 60 days, should we
In
file?
6 months,
I'm sorry, 6 months.
you will file a new order that it's dismissed with prejudice.
Okay.
Okay, I think this meets everybody's needs and comports with the law. I'm stretching it a bit, but he's not a lawyer and he has been ill, and it's been demonstrated by what you've even put in your pleading. He's been on a number of medications. He's gone through, I mean, losing your foot, half a foot even is traumatic. So I'm sure he wasn't able to get around and all of that. And I mean, so I don't know if it warrants tolling it or not, but we'll have an evidentiary hearing. Or you and your firm may decide, let's just see if it's gonna hold up on the merits, and we'll do an SD on, motion for summary on, a different issue. I don't know.
So you want us to file another motion or just an order?
Well, again, it depends how this goes. You
Okay.
will file an order of dismissal with prejudice 6 months from today, if I, or from tomorrow, because the order would be effective starting tomorrow, right?
Sure.
So 6 months from tomorrow, you would sign, if nothing happens between now and 6 months, if he doesn't come back with a lawyer and clean this mess up, it's dismissed with prejudice.
Okay.
If he comes back during that time, I am not barring you from filing anything else, but his attorney will need to file a complaint that's appropriate with the proper notices, etc. But he also will have to show, should you want him to, why it's proper for this court to toll the statute, and you will show why it's improper.
Okay.
So I'm leaving this issue open because it really does take an evidentiary hearing or an offer of proof.
Can I ask a question?
Yes, sir.
So Dr. Dunn was the doctor that actually told me that the Bactrim was the improper.
So he's one of
medication.
your witnesses.
So I get that. Would an affidavit work from him?
I suspect it will, but I can't give you legal advice.
All right.
You're a lawyer.
I'm not.
Yeah, and you need your lawyer to talk with Dr. Dunn and any other expert he's.
I appreciate your opinion. Thank you very
Okay.
much.
This isn't something where you can go home and start waiting. You gotta start going home and calling lawyers, the State
comprehend.
Bar of Michigan. There are a number of lawyers who do this work, who do it on a contingency, which is really what you're asking for, sir. You need a contingency basis. And it's really sad, and just let me make a record. One of the reasons I'm doing this as well, not only because I can see your illness, and it's really here in the pleading that was filed, this long history, but courts have become courts of the rich. That is not our Constitution. That's not the intent of our laws. There should be equal access to the court, whether you're rich or poor, whoever you are. And it is expensive to come to court, and many people do not come to court when they have a right to come to court because they simply can't afford it. And every attorney is obligated to take pro bono cases. I know I took more than my share when I was in practice. So I hope that you find someone. The State Bar of Michigan is a good place, but also there are a number of personal injury firms who would hopefully be happy to take your case on a contingency. Doesn't mean you pay nothing, but it's a whole lot better than paying hourly.
I appreciate your.
Does that make sense to you, sir?
To a degree. Let's
Okay.
put it that way.
Well, and, you know.
But I get it.
Yeah, I can't hold this open forever, and, defense
No, I
has a-
fully
Yeah,
understand.
and defense has a right as well to closure of this, and it wasn't done properly, I get it. And sadly, like I said, we've become the courts of the rich, and that's not right. So I understand your illness, I don't know what your financial situation is, that's not before this
I'm
court,
not
nor
rich.
do I, you know, but it doesn't matter, even if you seem to have enough money to live, litigation is expensive. Might take a whole chunk of your social security, that's not right. So there are lawyers who should help you, so I wish you all the best. And counsel, do you have an order? Or would you like to
A
see
messy
one?
version.
Okay.
Do you want to see what I have?
Sure.
Okay. we took right over.
Okay, thank you.
That might be a note to myself.
Okay. Probably good enough. There'll be a transcript for any attorney who takes this. And I'm putting that it does not close the case because technically
Sure.
it's gonna be really open for 6 months.
Okay.
Make copies. All right,
Thank you very much.
good luck to you, sir. Thank you.
Thank you.
All right,
Can I read?
nope, wait for a copy of this, because you'll need it. We'll give you 2 copies. You'll need one to give to hopefully your new lawyers. This is docket 19815 NH.
Good afternoon, Your Honor.
Just a moment, just give me one moment.
Of course.
One more copy? I'm sorry. Okay, Okay, thank you. Yes.
All right, now. Is this one?
Yep.
This is docket 19-815 NH Karen Stewart Hinckley as personal representative of the estate of Hayden Raymond Timothy Hinckley versus Dr. Amy Federico. Counsel, your appearances.
Yes, good afternoon, Your Honor. Leon Walsh on behalf of the plaintiff.
Then, Your Honor, Sylvia Mansour on behalf of defendant Dr. Federico.
All right, thank you. And this is a motion to approve settlement and distribute proceeds.
That is correct, Your Honor. We have the personal representative present. We can place her under oath.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
You may put your hand down, and could you please state and spell your name for the record?
Karen Stewart Hinckley, KarenStewart -Hinkley.
Thank you. And you've reviewed all the documents?
Yes.
All right, counsel, you may proceed with the inquiry.
Ms. Stewart Hinckley, you are the personal representative of the estate of Hayden.
Yes.
And Hayden was your husband?
Yes.
And in your representative capacity, you brought a malpractice action against the defendant, correct?
Yes.
And you understand that there has been an offer made to settle this case, correct?
Yes.
And you understand that you have the option of saying no to the settlement offer, an option of going to trial where you could receive more or less or nothing at all. Correct.
Yes.
And you understand that by entering into this settlement that you are waiving any further claims for the injuries that occurred in association with this incident, correct?
Yes.
And you understand that you'll have to comply with the terms of the settlement, including the confidentiality provision?
Yes.
And knowing these things, do you think the settlement is in the best interest of the estate? And are you asking the court to approve the settlement?
Yes.
With that, Your Honor, I have no further questions. I would point out that there was a guardian ad litem appointed for the minor child's interest in this case, which a report was submitted and filed with Your Honor.
Did anyone force, threaten, or coerce you to enter into this agreement?
No.
Other than the agreement, was anything promised to you or any of the minors?
No.
And you think this is in the best interest of not just yourself, but all of the minors who are involved?
Yes.
All right. I don't have any problem signing the order, and obviously the numbers that were provided. There is a proposed settlement here. It's an exhibit to the motion to approve. Was that under seal or not?
That was not under seal, Your Honor. I think there should be a redacted version of the attachment.
Okay, because I have, well, so what was filed, was it redacted or not? Because if not, I'm putting the, whatever has the numbers under seal.
What was filed was redacted, but a copy was submitted, Your Honor, unredacted.
Okay, so I am the only one that has the unredacted. What was filed is redacted.
That is correct, Your Honor.
Okay, thank you. I will, this only goes in my file and it won't go anywhere else, so court will sign the order that was attached. And on behalf of defendant, you've seen the order. Any objection?
I've seen the order, Your Honor, no objections, and I have nothing else to add.
Thank you. All right, court has signed this. It's ready for entry. It does comport with what's been applied and made record of, so we will get a record or a copy of this to you. Would you like it scanned or mailed to you, counsel?
I would be okay with scanned, Your Honor.
Whatever is easier for the court.
All right, well, I guess I'll leave it up to my law clerk and get that done. We're giving it to the clerk now, and we're gonna get it out to you as quick as we can. Thank you very much, and ma'am, I'm very sorry for your loss.
Thank you.
Thank you, that's all.
Thank you, Judge.
Next matter, the one you already have.
Is what? Waldo? Hold on. What is it? Waldo,
Yep, that's the next one.
motion to compel.
Let me find it.
You call that one?
This is docket 25-914-NI, Raquel Waldo versus Troy Dexter. Counsel, your appearances for the record. We have anybody?
Sounds great.
I suspect they figured out that once it was in front of me, I was going to order discovery or dismissal, and they resolved it themselves, but didn't have the courtesy to call us. So this is withdrawn. Next matter.
Hold on.
Yeah. We're gonna figure out what it is too, so you guys. This is docket 25-3031, CH, I'm sorry, Nancy, were you ready?
Kind of, but go ahead, I got it now.
Yeah, okay. This is 253031 CH Mint Construction LLC versus Joshua Simon versus Sustain Management LLC and Isaac Motley. Counsel, your appearances?
Good afternoon, Your Honor. Aaron Matthews on behalf of Mint Construction, Sustain Management, and Isaac Motley.
Thank you.
Good afternoon, Your Honor. Ryan Stern on behalf of Joshua Simon.
Thank you. And this is defendant's motion for summary. Again. Is it just against Sustain Management LLC?
Your Honor, there's two motions up. There's a motion for summary disposition against Mint Construction and a separate motion for summary disposition against Sustain Management.
Okay, can we just pull them both? I think they're, yeah, there's this covered. Okay, I didn't know there's several differences. Okay, you may proceed.
Judge, you want me to approach?
Please, at the podium, it's easier for the court reporter.
Good afternoon, Your Honor. This is Joshua Simon's motion for summary disposition against Mint Construction. As you've probably seen from the briefs, Mint Construction is an unlicensed contractor who filed a lien against my client's property. According to the Michigan Construction Lien Act, only people have a right to lien: laborer, supplier, subcontractor, contractor. Mint Construction doesn't fall in the category of laborer, supplier, subcontractor. Therefore, they must have filed as a contractor this lien. They are an unlicensed contractor. They have not provided a license. And in fact, they admit that they're unlicensed. As you know from MCL 3392412 and the case of Stokers versus Milling Roofing, an unlicensed contractor is precluded from maintaining any action for enforcement of a lien or collection of fees. Mint does, in their response, despite their complaint saying one thing, the construction lien saying one thing, the affidavit. I'm sorry.
Complaint saying one thing, their construction
Lien
lien.
and affidavit. Mint tries to characterize its work as cleaning and handyman services to collect this alleged debt. However, a handyman and a cleaner do not get lien rights. They're precluded. I mean, the lien, regardless of whether they're an unlicensed contractor or claiming to be a handyman cleaner, there are no lien rights. They don't provide any documents, evidence, case law, statute that allows them for lien rights. With regard to their other claims, so as the one property they claimed a lien, they can't collect. As the other property, they did not claim a lien for $3,500 approximately for, I guess, cleaning handyman services based on actual authority. They're claiming that Sustain, as the management company, had authority to hire them on behalf of Joshua Simon, and they rely on a management agreement, which is attached as exhibit for that authority. However, if you look at the management agreement specifically states that Sustain is authorized. Sustain is to provide cleaning and handyman services at $50 an hour. Sustain and Mint are owned by the same person, Isaac Motley. His affidavit states that he is the member of both entities. So in essence, Isaac Motley, on behalf of Sustain Management, has an agreement with my client to manage these properties and to do the maintenance and cleaning for $50 an hour. He hires his other company, his unlicensed contractor, to do these services for $60 an hour. And the invoice is attached to their response. It says $60 an hour. The agreement says $50 an hour. It also states that any Sustain's authority to contract for services is capped at $500 without authority. They're claiming they had authority, but it doesn't make sense. They had authority to charge my client higher from my client. So with regard to our motion for summary disposition, again, they haven't provided any evidence of authority. You know, I have submitted request for production documents. They submitted over 700 pages of documents, and there's nothing in there with regard to the authorization except for that management agreement. Would you like me to argue this other one also at this time, or do you want to?
Please.
Okay. With regard to sustained management, my client entered into the agreement with sustained management to manage properties. We submitted requests for production, requesting all licenses. In response to our request for production, they responded, they don't have any licenses. There are no licenses. So I filed the motion. Under the occupational code, in order to manage residential properties, they must be licensed. And that's MCL 339.2512. And again, under the case law Curry versus West Point Hills, to maintain an action for compensation, they must not only have a license, they must affirmatively state in their complaint that they were licensed. Based on a reading of the complaint, there is no allegation in the complaint that they're licensed. They do argue now that they submitted a screenshot from Laura saying that they're licensed. It doesn't allege that in the complaint. And in response to request for production, as I've sent it to you, they allege they're not licensed. The other thing is that they provided approximately 700 pages of documents in response to request for production. They're seeking compensation from my client. In 700 pages of documents, there is not one invoice to my client. There's not one request for payment. There's not one allegation of debt. There's nothing. They don't attach it to their complaint. They don't attach it to the response. It is as if they filed this in retaliation for our defense and our counterclaim. If you have any questions, Judge, I'd be more than happy to answer them.
So this goes in regard to they can't file a lien, right?
They can't file a lien or pursue compensation.
Because they're unlicensed.
Correct, Your Honor.
Okay, let me see what they have to say.
Afternoon, Your Honor. Again, Aaron Matthews on behalf of Sustain Management and Mid Construction today. I'll go in the same order. The council did start with mid construction. Mr. Simon appears to be taking the position that a residential builder license is required for any entity asserting a construction lien, and that's simply not accurate. Indeed, even the Construction Lien Act itself includes a number of activities that amount to, quote, improvements, end quote, that clearly do not require a residential builder's license. And he actually quotes the statute in his reply brief, I believe. And those things, among other things, include activities such as surveying, clearing, ornamenting, landscaping, etc. The list is not exclusive. It says including but not limited to.
Slow down, sir. My court reporters have a long day.
Thank you. I'm sorry, Your Honor. So it is not an exclusive list. Moreover, there are many activities associated with the construction trades generally for which no licensure is required in Michigan. Painting is an excellent example. As early as 1926, it was recognized that painters are entitled to construction liens. That's the case of Breed, B-R-E-D-E versus Rose, 236 Mich 651. Yet painters are not required to be licensed builders. At one point in time, they were required to be licensed alteration contractors, but that was removed.
They were
Required to be licensed alteration contractors, but that requirement was removed in 2018, 2019. So it's simply false that any person asserting a construction lien has to be a residential builder. In fact, there are other types of licensures. There's the residential alteration and maintenance contractor. There's other types of licensure that are available under the occupational code. But again, the Lien Act itself notes that improvements is a broad category. And it's not limited to the type of conduct for which a builder license is required. Mint Construction has submitted evidence, including an affidavit and the supporting invoices, supporting its position that the work performed did not require licensure under the occupational code. They are aware of what requires a license and what doesn't, and they do not engage in work that requires a license. None of this work required a permit to be pulled, for instance, a building permit or modeling permit, nothing of the sort. If Mr. Simon wants to challenge individual tasks on a line-by-line basis that were performed, that's beyond the scope of the present motion. This motion asserts that we had to be licensed, period, and that's simply not true. If he wants to go line by line, that's something that could be taken up at the appropriate time. I would contend that that's a matter for trial. But at this point, at the very least, there's a genuine issue of material fact as to whether the work required licensure that would preclude the entry of summary disposition based on the licensure status.
So did any of the maintenance, because there was handyman work, cleaning, maintenance and repairs, did any of the maintenance or repairs rise to the level under your theory of construction?
None of it rose to the level of requiring a contractor's license, Your Honor. And it's detailed in the invoices that we've submitted. There was there's deep cleaning, there was adjusting cabinet doors and things of that nature. These are residential rental properties. They're not residential properties, they're rental properties, and there's a distinction there too. And they were in poor shape. And so our crew, Mint Construction's crew, went in and was doing the work that was necessary to try to get them into a condition where they could be rented out. And again, if there was, and I believe that even in the invoices, it notes that there at times, if there were things that went beyond what they can do without a license, that would be hired out, and they'd electrical work, things of that nature. But again, they did not do any work that required a license. And again, that's supported by our affidavit, and there's no evidence. There's no evidence submitted by Mr. Simon contradicting that.
So was a lien filed?
Yes, a lien was recorded against one of the properties.
But on that one property, there was nothing that elevated to licensure?
Correct. The work, we contend that the work amounted to improvements for purposes of the Construction Lien Act, giving a lien rights, which again is a very broad definition that is not exclusive and includes things, landscaping, clearing. So if you clear a lot, for instance, that would amount to that, surveying and some other things actually would fall into that don't require a builder's license. So with respect to the lien, we believe that summary disposition is inappropriate on that count. As for the
but a lien can't be filed if you don't have a contractor license.
That is not correct, Your Honor. Only if the work you're doing requires a license.
Okay, but none of the work that was done required a license.
Correct.
So why is there a lien?
Because you can record a lien for things that don't require a license. Painting. A painter can come in and paint your house, and if you do not pay them, they can record a lien.
Not generally without a court order, can they?
Yes, they can. Again, it goes back to 1926 Supreme Court decision. They were called mechanics liens back then. But a painter not being paid has a right to a lien. And that case was cited, by the way, with approval more recently. It's not antiquated law. It's been relied upon, but painters can do that. It's a non-exclusive list of improvements that give rise to construction liens. As for the purported lack of privity between Mint Construction and Mr. Simon, as alleged in the pleadings and supported by the affidavits that we have submitted, we've submitted 2 affidavits. Sustained Management was acting as Mr. Simon's agent with actual authority when it engaged Mint Construction. As such, Mr. Simon, as the principal, would be bound by that agreement. To the extent that Mr. Simon asserts that he did not authorize the work, the affidavit of Isaac Motley disputes that and asserts that he did, in fact, authorize this work. And so at the very least, there's a genuine issue of material fact as to whether the work was authorized. That would preclude summary disposition on the theory of a lack of privity. The third basis for the motion as against Mint Construction, which I don't believe argument was provided today, but it was in regards to an unjust enrichment claim. we've asserted an unjust enrichment claim as an alternative to the contract claim, as is common. Mr. Simon argues that the existence of a contract between Mint and Sustain precludes an unjust enrichment claim as against him. But what he, and he cites several cases, but what he misses is the key point is an unjust enrichment claim is only precluded by an existing contract if that contract is between the same parties. So in other words, yes, we agree. If ultimately the court or jury finds that there's a contract directly between Mr. Simon and Mint Construction based on the agency principles, then yes, the unjust enrichment claim is not necessary. But in the meantime, there is at least it's a valid claim as in the alternative in the meantime. So you can't have it both ways. Either there is a contract or there's an unjust enrichment claim.
There isn't a contract?
There either is or the unjust enrichment claim is appropriate. As for this complaint or the motion as against Sustain Management, the sole argument is that Sustain Management lacks a real estate broker license. That is not true. Sustain has at all pertinent times had a valid real estate broker license. We've established that by the affidavit of Isaac Motley. It was easily discoverable by searching the state of Michigan license search website. In response to the request for production, we did not produce a copy of it because my client did not have a physical copy of a license at that point. I have since requested one and received it, and I'm happy to share that today. But again, the affidavit establishes that there was a license. Mr. Simon and counsel could have simply searched that database at any time to find that. They never asked via interrogatory whether there was a license. They simply issued a request for production to give us any and all licenses, period. No context, didn't say give us a copy of your builder's license or broker's license, etc.
Did you provide the licenses you have?
We did not. I said that we weren't aware of any that were in our possession that were relevant here. Because again, it was so broad, I didn't know what type of licenses he was referring to be frank.
Did you ask for clarification?
I did not, Your Honor. But again, we were licensed, and it could have been searched for at any time. As for the issue of the counterclaim that Sustain filed not affirmatively asserting that it had a broker's license, we acknowledge that oversight. To the extent that the court is otherwise inclined to grant the motion on that basis, we would ask for leave to file amended counterclaim, which I have with me today that I can file. Notably, the case upon which they rely, Curry versus West Point Hills, the court there did grant 20 days leave to file an amended complaint, and we would ask for the same to the extent the court is otherwise inclined to grant.
Thank you.
Thank you, Your Honor.
Final word of motion.
Yes, Your Honor. Right out. Mint Construction's response. There's no citation to any case law that a painter is entitled to a construction lien
There's no, I'm sorry, and there's no citation.
whatsoever in their response stating that a painter is entitled to a construction lien. There's no case law whatsoever. He mentioned a case during oral arguments right now. I've not reviewed it. I've not been privy to it. I don't even know if that case even exists, but it's not in his response, and he doesn't rely on it to the extent that his responses. With regard to the unjust enrichment claim, I did mention it in my brief. That there is case that says MCL 339.2412 precludes an unlicensed residential contractor from enforcing a construction lien, even if the Construction Lien Act itself does not prohibit it. And that is 84 Lumber Company LP versus Pagel versus Frey. It's an unpublished 2007 decision, and I attached it as Exhibit F to my my motion.
Well,
So there's two steps, in other words, Judge. There's two laws. There's the Michigan Occupational Code, and then there's the Construction Lien Act. You don't even get to the Construction Lien Act unless you comply with the Occupational Code. And the Occupational Code is the licensing requirements. You know, a contractor is required to be licensed to file a lien. Unless you're a supplier or a laborer working for a contractor. That's the only exception.
What's your response to the unjust enrichment? I mean, there was clearly work done.
The unjust enrichment claim, again, there's the case law states that they don't get equity rights, they don't get contract rights, they have no collection rights if they're unlicensed. They are precluded from any claim for compensation, whether there's work done or not.
But let's put it in perspective.
And it's to protect homeowners.
Totally agree with that. I like that law. However, if the work that was done doesn't rise to construction and it's cleaning, etc. You know, if someone's cleaning my house and they don't have a license, they can still sue me for unjust enrichment, right?
That is correct.
So what's the difference here?
The difference is he put a lien on the property,
I got the
claiming
lien
that.
part. I got the lien part.
That's the difference.
I got the lien part,
The
but the
difference
rest,
is that he alleged that he did improvements to property. It wasn't
That he
until
didn't.
that he did improvements to property. I'm sorry, in his complaint and in his documents. And when I filed this motion, all of a sudden it's cleaning services. If you look at his exhibit to his response bill, put in the invoices, replace whole decks. Is that cleaning and general maintenance, remove and replace the entire deck? Repair concrete steps. Repair the back porch, remove and replace deck boards, repair garage walls, use OSB to patch walls. That doesn't sound like cleaning services to me, Judge, and this is his exhibit. These are his exhibits, not mine. So he's provided no evidence and no legal support that he's entitled to a lien. Had he not filed the lien, had he not claimed himself as a general contractor, then yes, he might be able to get away with some of the stuff under the cleaning services, things that aren't required a license, but that's not what they did, Judge.
okay. It's very clear that there are multiple genuine issues of material fact. I would also agree, I don't have any case law about a painter, I think what you asserted in regard to painting. I'm going to allow you to present that. I'm also going to allow you to leave to amend. You'll have 30 days leave to amend. I don't know that all of this, I think there may very well be unjust enrichment. I think there's probably a combination of work that should have been done based on the assertions of both of you. Should have been done by a licensed contractor, but there's also a number of things that didn't require licensing. Clearly, somebody owes somebody money. And so we're going to, I guess, go to trial. That'll be the next step. I don't know where you are in discovery, but I'm also going to order that the lien be removed for absent an offer of proof as to the licenses, the specific work that falls under it. I am very confused about both of your assertions are so far apart. I think this case is going to end up in trial and a battle of the experts and licenses and statutes. I will grant you another motion, either a motion for reconsideration or a subsequent motion for summary disposition after the complaint is amended. I think there are a number of different issues here and should have been pled in the alternative. So we're going to trial. Have you been to mediation? Case evaluation?
Not yet, Judge. Me and co-counsel are discussing mediation We're in the
You're
process
not
of discussing.
discussing it, you are going.
Well, I mean, we're discussing agreeing on mediators and scheduling it, Judge.
Okay, so let's get
We're
that
working on,
scheduled.
we're working on scheduling, Your Honor. The first mediator we reached out to just has no availability, so we're going to our second.
They are very, very busy, and
Yeah.
there are some really good ones who deal with
Yeah,
construction.
we've talked about Alan Himmelho. I don't know if Your Honor is familiar with
I
Mr.
know,
Himmelho. He's well versed in construction, and I mediated a case with him last week, in fact. He's
Great.
done a great job. So,
Okay, so, and are you going to then file an amended,
for sustained management, it's counterclaim against Simon. Yes, I can file an
whatever
amendment
you
there.
all want to file, have fun, file it, let's get all of this done. Seems to me work was done, it's a question of what gets paid, how it gets paid, who pays it, and what's licensed and what's unlicensed. So sort it out, and I need some case law next time.
Your Honor, with regard to the lien.
The lien's going away unless you can do a motion. I'm gonna give you 20 days to remove the lien, or you can file a motion for reconsideration and show me why it needs to remain. But from what I've heard here, it shouldn't be there. No authority.
For the motion to reconsider, Your Honor, you want a hearing on that as opposed to?
Well, you file your pleading and then I'll look at it, but based on what you present, I will. In this case, I may very well ask for a responsive brief and then I'll decide if I want a hearing.
Okay.
All right. I'm always happy to reverse myself, but when I look at this and then read what you have submitted and then heard your arguments, this case isn't getting dismissed, but there are multiple layers of issues. So you want to clear something up with a motion for reconsideration? I'm always happy to reverse myself. But I just need further case law to back up what you stated here that was not in your brief. All right?
Was that 30 days, Judge?
30 days to
amend?
file, yeah,
30 days to amend, 20 days to remove.
yeah,
Thank you, Judge.
thank you.
That's one more.
It's all for the record.
There's one more quick comment off of this.
Okay, next is docket.
I need to.
Yeah. Yeah, you,
I haven't seen this in that long, I don't know.
What's the case? 22, it's Blake, Capalas, Loma.
2:30.
I have 1, 2:30. Oh,
Yeah.
I see, okay. I was looking for, I thought it was, someone else.
Okay. This is docket 22-187 NZ Blake Capalas hyphen Lerma, which is a gate building and restoration LLC, and Joseph Bermudez. Counsel, your appearance for the record.
Good afternoon, Your Honor. Michaela Dalrymple for the plaintiff, Blake Copulus Lerma.
And Mr. Madaloni is supposed to be here for defendants. Is anybody here on behalf of defendant?
With the copy?
Okay, and you have, is Mr. Madaloni representing you?
I was never contacted by him. My wife said that I had a letter to appear today, so I'm here. I never spoke with Mike Madaloni.
I'm sorry, what is your name?
Joseph Bermudez?
So are you part of this gate building?
Yes. The
So-
owner of Agape Building and Restoration.
Okay, can you come on up here, sir? Please raise your right hand. Do you swear or affirm the testimony you're about to provide with the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Okay. Counsel, was there an agreement here? This is a motion to enforce settlement agreement. So you did reach an agreement. Was that mediation, case of L, or what?
So the settlement agreement was reached after a period of discovery, and the case was actually resolved in June of 2023, with the final payment under the settlement agreement to be made by June of 2024. There is still $3,034 outstanding under the terms of the settlement agreement.
Okay. And was that against the LLC or Mr. Bermudez individually? How was that?
I believe that it was both defendants, but let me double check really quickly.
Because I have that the settlement agreement and general release is entered into by and between Gate Building Restoration LLC and Joseph Bermudez, which technically he can talk about his end of it, but it needs a lawyer to represent the LLC.
Correct, Your Honor.
Okay, so these monies are outstanding. Was any, so there were no monies paid under this, or was there some money paid?
There was some money paid, Your Honor. The total settlement was for the gross sum of $50,000. And it was to be made in a series of installment payments, with the final payment to be made June 5th of 2024. And installment payments slowed and then came to a stop, and we still have money owing.
And I didn't get the end of that. Installment payments then came to a stop and what?
We still have money owing.
And that's the $3,034.
Yes, Your Honor.
Okay, so it looks like the monies were joint and several.
Correct.
Okay, so let me just say, I don't know where Mr. Manloni is. Maybe he was not retained after this, but Mr. Bermudez, you can only talk about you because the LLC is a separate entity and it must be represented by a lawyer, okay? So are you aware that the $3,034 is still owing?
Yes.
And so when is it going to be paid?
I have been making payments. My last payment that I made was on 10/3 of 2025, which is $300. So that balance is actually under the amount that she mentioned, which was $3,034. So it should be minus $300, but I have made payments. I have some receipts here. Our business closed after this lawsuit, so I had 6 employees, not 6 employees, but 6 employees working in our office. Our office is totally shut down. I'm still responsible for the payment though, so I have been making payments.
So what is your commitment to make payments? Is it $300 a month, a week, or what's the story here?
Well, I'm overdue. I'm past due, as you said. I think it was due in 2020.
Got it. What's your plan for payment?
So this is our slow season. I'm the only one out of our company working right now, and we don't expect to pick up until probably March. So I could probably only do like $150 until springtime, and I'm sure I could get it paid off quickly thereafter.
So what is this, $150 a week, a month, bi-weekly?
$150 a month, and then I could pay the rest off in bigger installments, like $300 a month, maybe April 1st starting.
Ma'am, are you willing to take $150 a week?
A month?
Or I'm sorry, a month until April, and then I'll pay $300 a week?
A month.
Or I'm sorry, a month. I keep saying a week, but a month?
Would you please repeat that? I was weeks, months. I was a little confused.
Okay. He says he just paid $300. Did you receive that?
The $300 that we had received was included in that amount in the motion, the $3,034.
Okay, so $3,034 is the balance. Is that correct?
Correct, Your Honor.
Okay, so this is the slow time of business for him. He is willing to pay $150 a month, and then as of April 2026, increase it to $300 a month. Is that acceptable for you?
That is acceptable, Your Honor, but we would like to reserve the right to seek default if he does miss one of these payments.
Oh, you certainly can do that. You know, but the fact of the matter is, you all can do these chess maneuvers. At least he is offering to pay, which is better than what I see. The fact is, he could probably go and file bankruptcy and then you get nothing. So I would take what he's offering. So, and yes, you can always use the court rules, file default, and do whatever it is you want to do, seize assets, whatever. I don't know if he has assets to seize because he closed the business. Sir, are there assets that you can sell from the business?
No.
Okay, so $150 a month. So we're in November. Did you make that $300 payment in October or November?
That was October.
So can you make $150 starting in November?
Yes.
Great, $150 per month. In April, it will start $300 per month until this is filed or paid in full, I'm sorry. Yes?
Yes.
Okay, and then once it is paid in full, I'm sure council will file the necessary paperwork to show the world that it has been paid in full.
Yes, Your Honor.
Anything else I can do?
That's it.
And if you would like to prepare an order, I'll be happy to sign it.
Absolutely, Your Honor. Thank you.
Thank you, that's all for this record.
Thank you.
Thanks for being here, sir, thank you. Give me a minute, please. What is this now?
It was just supposed to be a pretrial, so I don't know what's going on with it.
Every time someone talks on the Zoom, it gives me a little heart attack. So loud. Oh, hold on.
What time was it scheduled for? It is time.
One, was it?
All right. Do you have this? It's Harold. Harold?
Oh.
All right, Nancy, when you're ready. Okay, this is docket 25-4483 FH, People of the State of Michigan versus Jeffrey Harrell, Harrell. Counsel, your appearance for the record.
Good afternoon, Your Honor. Assistant Attorney General Carissa Williams on behalf of the people.
Your Honor, Jeffrey
right.
Kaplan, Jeffrey Kaplan, P 74943. On behalf of the defendant, we're both appearing by Zoom.
All right, sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
All right, this was scheduled for a pretrial. Has that been held?
Your Honor, I have had conversation by email with Sarah Brenner. What we're asking for today is just another pretrial date, so I can discuss with my client a new offer and how he wants to proceed. I suspect this is going to resolve itself in a plea, but we're just asking for another date.
Has he been making payments at all?
So again, there's a wage garnishment in place. I talked to Ms. Brenner this morning. He is making payments on the garnishment. Unfortunately, he's got other non-support cases. There's very minimal amount being attributed to this case. I believe it was only 6 cents of all of his garnishment that is being attributed to this case.
6 cents?
I'm sorry?
6 cents?
6 cents. Sorry. I'll let Ms. Williams speak.
Stamp is more expensive than that. What? Okay. Lost the rest of the- I need to find a pretrial on a child support case. Or what's the soonest we can get them in without doing it next year? Do we have some plea dates that are odd? Thank you. Tuesday, November 18th at 11:30, final pretrial.
Thank you, Your Honor.
Can I work with your schedule, man?
Someone from our office will be here the 18th.
Yes, at 11:30. Sir, you'll need to be here.
Yes, ma'am.
I would come with a plan for paying more than 6 cents.
They're taking almost my whole paycheck.
we'll discuss that further, Jeffrey.
And you can be available by Zoom. You're living in Georgia, is that where you're living?
I'm Maine,
Maine, what is your current address, sir?
198 Lee Road,
What road?
Lee Road, Lee.
198 Lee Road in where?
Lincoln, Maine.
Lincoln, Maine.
Lincoln, yes, ma'am.
And is that a house or an apartment?
A house.
And what's the zip code?
04457.
44457?
Yes, ma'am.
Are you employed, sir?
Yes, with GT Independence.
DTN?
GT Independence.
GT Independence, what is that?
It's a home health nurse.
Okay. Are you working full-time?
No, ma'am.
Why not?
Because that's the only hours I can get right now. I'm trying for more.
Are you licensed?
That's the PSS.
It's what is it? DSS or PSS.
Okay, what does that stand for?
Personal support specialist.
Okay, can you do that at a hospital or otherwise, or can you get other patients or whatever it is you do?
No, ma'am.
Why not?
Because right now it's my mother-in-law who I'm working for.
So how many hours are you working?
27 a week.
27 hours a week?
Yes, ma'am.
Well, are you living in the country or are you living in the city?
I'm out in the country.
Can you make it to go work for somebody else to do something like McDonald's or, I mean, sir, you owe so much money, you can't be too proud to go get a second job.
I can try to. I'll see what I can do. Yes, ma'am.
Sir, you got an arrearage of $18,000 here. I don't know what your other problems are, but working part-time is not gonna cut it. The mother of your children is paying for your children. If you didn't want children, don't have sex or wear a condom. Meanwhile, we got children who need to be supported by both parents, not the state.
Yes, ma'am.
So figure it out, because I'm not going, if you think I'm harsh now, you wait and see when you come back and you don't make payments, because I can have you transported and you can work in our jail for a very long time. So you choose what you want to do, sir.
Yes,
Counsel,
ma'am.
you have a chat with him, please.
Yep, we will, Your Honor.
Thank you. That's all for the record.
Thank you, Your Honor.
Thank you.
Jeffrey, you can log off.
Go up to the